Good afternoon, welcome to ADA Meclis. We are once again discussing Karabakh conflict. This time we will try to focus on legal aspects of Karabakh conflict, specifically focusing on international law. And my colleague Nijat Mehmedli and I will be co-moderating this discussion. Our guest today is Member of Parliament, Mr. Erkin Qədirli. He is a prominent lawyer, prominent civil society activist, and I think it will be very interesting to learn his views, his perspectives on this issue. Erkin Məlim, thank you for joining us.
Thank you for inviting me.
Yes. First general question that I would like to ask is, Karabakh conflict is often discussed within international law, and Azerbaijani side is saying that we are acting based on international law, that international law is on the side of Azerbaijan. What does that exactly mean? What specific aspects of international law?
Well, to be brief, there are certain fundamental principles which the position of Azerbaijan is based on. And all of them are enumerated and even stipulated in the UN Charter. But even if they were not written, they come from the customary international law. These principles are the following. Territorial integrity, inviolability of state borders, political independence. And what Azerbaijan's position is basically what we have is all of them are violated. Now our borders are violated, territorial integrity is violated. Armenia does not even recognize our borders, not just because we don't have an agreement or limitation, etc., but they simply do not recognize by the fact of claiming part of our territory. On the other side, we have a fact of occupation, which is a result of military aggression by Armenia against us. So this in turn actualizes our right to self-defense, stemming from Article 51 of the UN Charter. But again, this is a customary international law. The fact that it is written does not add anything, because that article actually says that nothing in the present charter shall impair the inherent right to individual or collective self-defense. So it's an inherent right. It's not given. Right. And because it's not given, it cannot be taken. So briefly, this is our fundamental principles, the fundamental principle of international law that makes our position firm and right.
And these UN resolutions are also...
Well, that's in addition to that. Mm-hmm. Yes, the UN Security Council resolutions, which specifically deals with the certain occupied areas of Azerbaijan, 4 of them. We could talk about them later,
Sure.
Because the text and context are very interesting. Sometimes they give rise to conflicting interpretations, and we see how Armenia is trying to mislead international community about those resolutions by misinterpreting those resolutions, as if those resolutions do not concern Armenia. So they try to present that Armenia has no obligation under those resolutions, which is wrong.
You mentioned customary law, of course, and then I, from top of my head, I recall the customary law, the just war theory.
Yes.
Which is very important for this case particularly, and it's like in legal terms, it's jus ad bellum, and if you remember those 5-6 principles of just war, which is like last resort, proportionality, and etc. All these elements or aspects of customary law, just war theory, can be applied to in this particular case, so that we can say that, okay, in this case, Azerbaijan is conducting just war.
Well, I think it's a matter of preference. You can certainly rely on that theory, but you may choose not to do that, because, the leftist interpretations of the legal norms shifted some of the text, the meaning of them, and we have come to such an interesting situation where the term war exists in certain international instruments, like, for example, Hague Conventions, Geneva Conventions. But the politicians do not use it. They prefer conflict.
Right.
So they kind of trying to smooth the terminology. But war is war. You can call it a conflict if you want. What our right is about is the right of self-defense. This is more important than the term of war or theory of just war. Yes, there is a casus belli. We have a situation when we have a right to use our military force. But the Article 51, in comparison with some other articles, especially Article 2 of the United Nations Charter, which prohibits use of force, you have to take them into context. You cannot interpret them separately. Yes, Article 2 of UN Charter is a general provision which provides that states shall refrain from use of threat or use of force. But then Article 51 says that nothing in the present charter, the word nothing is very important, shall impair the inherent right of state which was attacked. The exact wording is different, but the meaning is the same. Now, what we need to understand is what self-defense is, what means attack, what constitutes an attack. Now, of course, self-defense is a kind of use of force when you have recourse to, when you are attacked. So attack can be measured by certain criteria, and the International Court of Justice in certain cases clarified this term. Of course, in our case, it's very clear. We are occupation.
Right.
So we don't need to elaborate or to refer to some other judicial cases. It's clear-cut case in our situation. So we are implementing our right to self-defense. We legitimately use force on our own territory to restore our territorial integrity.
Right.
So it's our inherent right. You may again call it war or a conflict, but if you call it a conflict, we should be careful, because there's another troubling situation with this term, and Azerbaijan actually had to deal with it for more than 26 years during all this negotiation period. Because many organizations and foreign states and even experts try to impose on us an obligation to peacefully solve the conflict. And I keep saying this, you can check it in the charter. There is no such principle in international law as peaceful solution of conflict. The United Nations Charter contains a principle of peaceful settlement of disputes. When a dispute evolves into a conflict,
It becomes kind of a war. Right?
Yes, Article 51 comes into effect,
Right.
the right to self-defense.
May I ask one follow-up question, Erkin Madam? This question is always in my head, and I always wonder why it's not happening. We have had international tribunals for Yugoslavia, for Rwanda. In case of Karabakh, there were clear war crimes, clear examples of war crimes, in Khojaly, for example, and generally ethnic cleansing. Is it possible that there will be some international tribunal investigating these war crimes, especially against Armenian military leaders and military commanders? Why it's not happening?
Well, it's a matter of political will. It's a matter of political will of the Security Council. Because the tribunals that you mentioned for Rwanda and former Yugoslavia, they were both established by the Security Council, acting within the Chapter 7 of the United Nations Charter. At that time, when they first decided to establish those tribunals, there were heated debate among scholars and lawyers as to whether those decisions were legitimate. Because the United Nations Charter says nothing about that. It doesn't say that. If you read the competences, the rights of Security Council, you will find nothing about establishment of international tribunals. Because the tricky situation is that the International Tribunal is a court, and it should enjoy the status of independency and impartiality. And when a political institution creates a court,
Right.
the reputation may be damaged.
Right.
But theoretically, there was a heated debate, but practically, we see that those tribunals work.
Happened.
Yes, they work. And the case law is very interesting. And some of the criminals were punished legitimately, justly. There is another criminal court, which is Permanent International Criminal Court in The Hague, which was established by a separate agreement.
ICC, you mean?
ICC. There's a charter. And this court is very interesting because it enjoys the status of international organization. Because all other courts are treaty-based organizations, treaty bodies of some other organizations. Like we have European Human Rights Court, we have International Court of Justice. All of them are treaty bodies. They are attached to certain convention, and they work under the umbrella of yet another organization. International Criminal Court is an independent international organization. So it's not a UN court. It's not a court of some other organization. The problem with that court is that we're not a member.
We're not. Azerbaijan.
Neither Armenia nor us. And that makes it inaccessible. So we cannot
Use it.
we cannot use it.
Sorry for interrupting
yes,
you,
sure.
but in this case, there is at least one instrument that we can use, which is stipulated in the Rome Statute of International Criminal Court. It's Article 12, Paragraph 3rd, which means that you can, even if you are not recognizing the jurisdiction of courts, you can still, address for ad hoc jurisdiction in certain cases.
There is a one possibility which we can try to use. I wrote about that on my Facebook page once. That either you need to be a member and then ask the International Criminal Court to investigate, or the International Criminal Court may itself initiate the investigation. But there is another option which belongs to Security Council. A Security Council may refer the situation, not the case. If Security Council believes that there is war crimes or crimes against humanity being committed on the territory of a state which is not a member of the ICC statute, Security Council has the power to refer the situation to the ICC. And then ICC will start the investigation, even if you as a state is not a member of the charter, of the statute.
So it is possible.
It is possible, but it is complicated because you need a decision from the Security Council, which is, for very obvious reasons, yet another problem. And also, one has to keep in mind that the ICC is a complementary body. So the first priority is given to states, and it is a sovereign power of states to investigate and adjudicate any crime. So in this situation, it is of course our sovereign right to open investigation, and to the best of my knowledge, the prosecutor office of Azerbaijan already started these investigations. So the problem with that is that you need to capture the persons who are
and deliver them
to the court.
Yeah.
This is another complicated situation. But again, there are different other mechanisms like universal jurisdiction, for example. Some states use it, not all.
But some of them revoke
Yes,
recently.
but Spain or Belgium, for
Right.
example, we can ask them. Of course, you will need to provide all the necessary documents. You need to persuade the authorities
Yeah.
of those states that these are the allegations are more or less based on certain facts. Then, if they decide, they can open their own investigation. They can issue a warrant. You know that there is a European warrant, arrest warrant. There is an international arrest warrant. So, and there are some cases when they use them, like against Pinochet, the Spanish court, or Belgium. They even issued a warrant, arrest warrant against acting Minister of Foreign Affairs of Congo.
When I saw yesterday, Erkin Qədirli, the images of former Kosovo president being taken to the tribunal, I immediately thought about Sarkisyan, who has acknowledged participation in Khojaly massacres, etc., etc. So I was wondering why, they're taking Kosovo, former Kosovo president, but they're not taking Armenian president.
Because Armenia is not a member
Right.
of this.
And to follow up on this, there were attacks on Ganja and Barda civilians.
Mhm.
And obviously, Armenian leadership is instructing these attacks. When we say about war crimes, what does that exactly mean? What does
good
it mean,
question.
war crime?
Thank you for this. This good question as a lawyer troubles me a lot because I had to explain it to the general, wider public. Many people confuse military crimes with war crimes.
Mm-hmm.
Military crimes can only be committed by military servants. So civilians cannot, by definition, commit military crimes. Because military crimes are crimes against military service, like disobeying the command.
I see.
That sort of crime. And military crimes can be committed both in time of war and in time of peace. War crimes, contextual meaning of this term is that they can only be committed during time of war. So one cannot commit war crime in peaceful situation. And there is also another element that war crimes can be committed by military servants and by civilians.
I see.
So
Politicians, for example.
yes, even if that civil person does not hold any official position.
I see.
But of course, people with a higher responsibility have, of course, the higher official rank, they have higher responsibility. And as the ICC statute provides, this is a very interesting development in the context of war crimes and crimes against humanity. Normally, to be held responsible for crime, you need to be aware of the crime happening, and you need to have a certain intent in commission of that crime. In the statute of ICC, International Criminal Court, for high-ranking officials, the mens rea, as the Latin term stands, the mental element of that crime, provides that you can be held responsible for a crime which you were not even aware of. But why is that? Because according to the position you were held, you held at that time,
Falls under your
you
responsibility.
had to know
Yeah, it's under
what
your
your subordinates had been doing. Because there is no excuse for example, I think Pashinyan, the Prime Minister, once either said directly or indirectly that he was not aware of a missile launch.
Possibly, yes.
Maybe I misunderstand something. But even if, let's imagine that Pashinyan says that I was not aware. Some crazy people did that. That is not an excuse.
He's still Supreme Commander.
He's a commander-in-chief. And he must be aware of what his subordinates are doing.
Mhm.
So this is a very interesting element. So again, the only problem is that neither Armenia nor us, nor Azerbaijan, were not members of the ICC statute. But we can use our own judicial system to punish.
But still, my question was about the particular article, which is Article 12, paragraph 3rd, which still means, and it's very clearly stated.
There's certain preconditions for that, which you have to meet, and which is difficult to prove. And again, there's certain political risks in that as well, because you open yourself for investigations. Not only what Armenian armed forces are doing in your territory, but also what your own armed forces are doing. So it's a very tricky situation.
Okay. My next question will be about the two types of international crimes, which is stipulated in Rome Statute of International Criminal Court. One of them is, the crime against humanity, and the next one is
Genocide.
And
aggression. There are 4 categories. Aggression, genocide, crimes against humanity.
Aggression actually is not defined yet because it was later was a...
And the problem with aggression, before, this is another interesting point, which also somehow compromises the reputation of the International Criminal Court. But that's not the problem of the International Court itself. That's how the international legal order is designed. For the ICC to consider the case of aggression, first the Security Council shall adopt a separate decision and confirm the fact of aggression. This is very strange from the judicial point of view, because in this context, the court will have to consider facts which were approved by a political institution. This is unacceptable for any judiciary in any country. But in this case, given the design of the global order, the crime of aggression has this problematic element. So unless Security Council establishes and approves the fact that yes, there is an aggression, the International Criminal Court cannot consider that case.
Another problem is that Kampala round has not entered into force.
Yes, that's
one of the.
But I was thinking ahead. So.
Okay, so that's good. So my question actually was about whether we can interpret Armenian military, or let's say the Armenian crimes in this case as because. If we look at the definitions of both crime against humanity and war crimes, we can see that both in place.
Yes.
So, but how we can interpret which one of them actually happened in this?
Yes, this is a question to be answered after investigation. Theoretically, the war crimes and crimes against humanity, they are distinguished by the context, because as we said, war crimes can be committed only during war. Crimes against humanity can be committed at any situation. And they are also, of course, can be committed during war. And some of them are similar. You have certain crimes which can be identically defined as war crime or crimes against humanity. You need to get into the context. And the context is this: normally, for a crime to be regarded as a war crime, it needs to be a part of a military attack. So there must be a certain plan. Unless there is a military plan, a crime cannot be called war crime. So, for example, launching a ballistic missile on any part of Azerbaijani territory, for example, Ganja. This is a military plan. You see that there is a plan
to implement it.
It's part of a military activity. And And also it needs to be done in a large scale, which we also have in our case. We see that they attacked Ganja, Barda, Tartar, Avdam, Avcabali, and even some inner areas of our country, like Khızır, Abşeron region, Mingeçevir, which are far away from the zone of military operations. So it is large scale. We have this element of being large scale. We have the element of being a part of the plan. For a crime against humanity, you don't need a plan. Yes, if there is no plan, then if you see that uncoordinated crimes, for example, there is no plan, then okay, by definition, you cannot say that this is a war crime. Then you shift to crimes against humanity. But the problem with the crimes against humanity is that their context is even harder to prove because they need to be widespread or systematic. Now, the difference between what's widespread and large scale is geographical understanding. Right? You just need to be in certain. Widespread means that there must be attack on civilian populations. It could be also geographically understood, but also mostly in terms of population. Yes. So it's not a small group of people. Yes. And systematic. So some crimes, for example, I don't know, attack on civil population, indiscriminate attack on civil population, up to, if you go down to, for example, even such crimes like, I don't know, killing people who are protected by international humanitarian law, they can be both defined as war crimes and crimes against humanity. All depends on context. Unless you know the context, you cannot clearly say which category this crime belongs to. The same is about genocide, for example. Genocide is also a crime which is legally hard to prove because the constitutive element of genocide is not the number of killings, it's intention.
Yes.
Because you need to have a plan or a policy to destroy the group of people, the group as such, not just a group of people, but as ethnic, national, religious, and racial, as such. And these two words, as such, is very difficult to prove. That's why we have seen this in international tribunal for former Yugoslavia, when the investigation started as genocide, but then they changed it to crime against humanity. And there's a crime in the category of crime against humanity, which seems to be identical to genocide, and it's called extermination. It's again identical to genocide, but without plan.
Yes, Erkin, we are coming closer to our discussion. I want to ask one final question for myself, and I think Nijat will have another final question. My question is about Chiragov case. It is a very important case, but unfortunately we don't know much about it. I mean, at the ordinary citizens level. Please help us briefly understand what is the meaning of this case and why it is important for Karabakh.
Yeah, it's briefly called Chiragov case but we need to know that it's not only Chiragov. There are Chiragov and others, a number of other groups. These are citizens of Azerbaijan who were forcibly expelled from the occupied territories, and they launched a complaint with the European Court of Human Rights, claiming that first, of course, they were forcibly expelled, their property is destroyed, and they are not allowed to visit the place of their residence from which they were. And it is not a unique case. European Court of Human Rights considered some other cases similar to this one. So it was not difficult for a European Court of Human Rights to decide it. And the European Court of Human Rights referred to its own doctrine of effective control, because in some other cases, like in Northern Cyprus case, Louis Zilou case, when a defendant state, Turkey in that case, said that we are responsible only on that territory where our constitution is applied. The European Court of Human Rights said that no, the European Human Rights Convention, unlike other human rights instruments of UN, for example, we have covenants on civil and political rights. The difference between them is that those instruments apply on the territory. They use this pledge. The European Convention of Human Rights does not use the word territory. It uses the word jurisdiction, and jurisdiction is a wider term. You have a jurisdiction to areas you effectively control, even if it is not your territory.
And they found Armenia guilty.
And they found Armenia guilty in this case because Armenia effectively controlled.
I see.
Armenia tried to defend itself that we're not occupying these territories. To which the European Court of Human Rights replied that we're not even considering the fact of occupation, and we only established that whoever is at effective control is responsible for human rights violation, and that's how Armenia was held liable for the violations.
Okay, my question stems from your answer. Actually, if you remember from the Charagas and others versus Armenia cases, in establishing effective control of Armenia over Karabakh Republic, they refer not just the documents of international organizations like OSCE and etc., but also they largely refer to the documents or files by international or non-governmental organizations like Human Rights Watch. So in this case, and we recently have witnessed that Human Rights Watch and other organizations, they clearly stated that Armenia used cluster bombs against Azerbaijani peaceful cities, I would say. So do you think that, I'm asking this question as a pure politician, so do you think that these kind of statements by recognized international organization will in future help us at least in some maybe lawsuits?
Hopefully, but I wouldn't be that certain. I wouldn't be too much optimistic about that because yes, majority of states are member states of the UN Convention prohibiting the use of cluster munitions, but Armenia is not. So technically, you cannot sue Armenia for violating international agreement, which Armenia is not a party to, and not only Armenia, some bigger states like United States, Russia, China, they're not party to that convention. Even Azerbaijan is not party. So, so it is difficult to use that particular international instrument. We can try. By the way, Armenia uses anti-personnel mines, which is also prohibited by international law. And again, 160-something states joined that agreement. But Armenia is not a party to that. So yes, there are certain obstacles, legal obstacles, for us to use those instruments. We can use them as a moral argument, yes, and we shall use, and we do use, as a moral argument. But there's also a jurisdictional problem, by the way. Neither Armenia nor Azerbaijan accept the jurisdiction of International Court of Justice. We are, by the very fact of being a member of the United Nations organizations, I'm also a member of the International Court of Justice. But for an International Court of Justice to consider a case, you need to accept its jurisdiction. And even if we do accept it sometime in the future, you need to Armenia to accept it. If Armenia does not accept the jurisdiction, even ad hoc jurisdiction, you cannot lodge a complaint against Armenia in the International Court of Justice.
Okay, thank you. Thank you, Erkin Qədirli, for this excellent discussion. We hope that this discussion has shed light to some of the important aspects, legal aspects of Karabakh conflict. We hope that this has educated the society about this complicated web of international law. And we would like to appreciate your time, Erkin Qədirli.
Thank you for having me. Thank you for inviting me, and I wish you all the success for this project,
And
for you personally, and for this reputable educational institutions which
thank you.
ADA
Thank you.
is.
Please stay tuned. Nijat and I will continue bringing interesting speakers for future talks, and follow our conversation on YouTube channel. Thank you.
Thank you and thumb up.